Essentially, can I just interrupt you? Can you kindly show us the rules under which you are coming?
I'm coming under the inherent jurisdiction of the court, because my lord will appreciate that it is under the inherent jurisdiction of the court that the court grants leave in such circumstances where we have taken a step and we are seeking to reverse the taking of that step. That is in the inherent jurisdiction of the court to grant. What a reasonable expectation at the time of closing our case that chairperson would be testifying. We had a completely reasonable expectation of that based on her own interest in any proceedings between that party or his successors in interest and such relying person or his successors in interest. Now, my lord, the effect of this conclusive presumption is also provided for in Section 24 of that Evidence Act, where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action. No evidence contrary to the conclusively presumed fact may be considered by the tribunal of fact. My lord, this legal position, as far as the effect of what was in the affidavits of the chairperson of the first respondent is concerned. This legal position was also recognized by this court in the case of Sefa and Asiedu number 2 against the Bank of Ghana number 2 and JMFI number 2 and Bank of Ghana number 2 consolidated. But if we can just, the citation, my lords, is 2013 to 2014, 1 Supreme Court of Ghana Law Report at page 530. My lords, this was a decision of this court comprising His Lordship and in the word, Justice of the Supreme Court as he then was, and Justices Bafuboni and Badegbe, Justices of the Supreme Court. And their lordships reversed an order of a single justice and in reversing that order, the lordships made reference to the terms of this Evidence Act. And Justice Badegbe, whose decision was agreed to by the other lordships, had this to say at page 539. By the operation of the effect of the depositions made in the application before the High Court, the applicant, that is the respondent Bank of Ghana, is caught by Section 26 of the Evidence Act, which is commonly referred to as estoppel by own statement or conduct, as provided for in NRCD 323 in the words that follows. And he quotes what I have already quoted. And continues, since the said paragraphs 6 and 7 give rise to a conclusive presumption within the scope of Section 24(1) of the Evidence Act 1975, NRCD 323, the court which held the application for leave to adduce further evidence ought to have come to the conclusion that the facts in respect of which leave was sought for evidence around to be led in the appeal had long been available to the applicant Bank of Ghana since the making of the application to set aside default judgment in the matter on 18 July 2012. And then they proceed to quote, Justice Gwadegbe proceeds to quote section 24, and then says, further, in our view, as the application to the trial court was prior in making to that made to the Supreme Court for the purpose of obtaining leave to adduce further evidence in the appeal hearing, the inconsistency between the two depositions must adversely affect the credit to be placed on the subsequent deposition, and so on. So, my Lord, the point that I'm making respectfully is that in this decision of the Supreme Court, your lordships determined that statements in an affidavit that had been filed in respect of these proceedings established a conclusive presumption which could not justify exercising a discretion to grant leave to adduce evidence. Now, in this case, we're saying by parity of reason that we have a situation where the chairperson of the first respondent has in affidavits made clear that the petitioner would in no way be prejudiced because the questions that the petitioner sought to have in interrogatories, those questions could be the subject matter of cross-examination. And my lords, obviously by that time, she had filed a witness statement, and she clearly intended and expressed that intention to testify. And my lords will see that in the statement of case of the first respondent, the statement of case filed by first respondent in opposition to the application for review, and that is one of the attachments to our application, and I believe that it is marked yes, it is marked recall
Chikata.
Yes,
Mr. Chikata.
yes, my lady.
Kindly clarify something for me.
Yes, my lady.
You want to reopen your case for the first respondent to testify as a witness?
Well, not the first respondent. We want to seek to reopen our case. And my lords, as I indicated, we are not seeking leave to serve a subpoena. The serving of a subpoena or the right to serve a subpoena is provided for under Order 38, Rule 10. The person that we intend to serve the respondent, to serve the subpoena on, is the chairperson of the Electoral Commission, the returning officer. That person is not the same as the first respondent, evidently. But that is the person that we intend to serve the subpoena on. It's not on the first respondent.
All right, so she is coming to testify in what capacity?
She's coming to testify on the basis of the subpoena.
But you
She's
said...
coming to testify on the basis of the subpoena because she's a public official. Milady well knows that subpoenas are very often used in the context where, for instance, a public official who may not wish to be identified as testifying, so to speak, as a witness of one party or the other, but who can be subpoenaed so that in their independent capacity, they can bring to the court matters which are relevant to the determination that the court is making. Subpoenas are generally set.
I asked this question because of your paragraph. Paragraph 15.
15?
Yes.
1-5.
Yes. He said, as a result of the ruling of the court of Thursday, 11th February, it has become necessary, I'm advised and verily believe, that my counsel use the subpoena powers of the court under Order 38-10 of CI 47 to compel the attendance of the chairperson or first respondent to appear and testify. So you subpoena her to come and testify in what capacity?
As a witness.
Of the first petitioner.
I'm not sure
of the
in what
petitioner.
capacity. She's a witness.
Witness of who? Court or the
No,
petition?
she's our witness, but as the evidence law allows, she is treated as an adverse witness, what in common law was referred to as a hostile witness.
You want to treat her as a hostile witness? Assuming your application is granted, you intend to treat her as a host?
Yes, that is what we're saying, naturally. And my Lord, respectfully, at this stage, her status as a hostile witness, adverse witness under the evidence, at this stage, that is not an issue before you.
No. So it's totally an issue, you see, because we have to exercise our discretion to grant or refuse your application. And we can only exercise our discretion on extremely appropriate grounds. We need to know what she's coming to do, whose witness is she going to be? And
my Lord,
the capacity is important.
she is coming as a witness of the petitioner described in the evidence laws of Ghana as an adverse witness, and in common law described as a hostile witness. That is the capacity in which she is coming. When your ladyship asked in terms of capacity, I was not very clear what capacity meant, but in this context, it is as an adverse witness. That is the capacity under the laws. And my lords, I was also alluding to the statement of case of the first respondent, in which, and that is exhibited to our affidavit as part of Recall 1, and it's exhibited Recall 1. It's exhibited as part of Exhibit Recall 1. Exhibit Recall 1 consists of the affidavits in opposition to a motion on notice for review, as well as the statement of case that was accompanying that application. And in the statement of case, which I was referring to, counsel states at paragraph 4, the petitioner does not suffer any injury to his rights if the application for review is refused, as he still has the opportunity to solicit the same answers during cross-examination, unless it is his case that he does not have the full complement of his case and needs the answers to fill in. So here is counsel for the first respondent stating clearly that we do not suffer any injury. The petitioner does not suffer any injury to his rights if the application is refused for the reasons that are given. And that is exactly what Mrs. Mensah herself states in her affidavit. So, my lords, if on the basis of that position that we found ourselves in, where there had been clear representations that this person was actually going to come and be available for cross-examination, it was within our rights to rely on that representation, which has, even under the terms of Section 26 and Section 24 of the Evidence Act, been determined to be a matter of conclusive presumption. And my lords, the reason I sought to separate this stage, where we are simply applying for leave to reopen our case, from the stage of the subpoena, and your ladyship is entirely right that you do want us to be candid with you about why we are going to subpoena, so that you can exercise your discretion appropriately, and I fully understand that. But the distinction that I wish to make, just for the sake of clarity, is that once, if your lordship grant us leave, and we filed a subpoena, which is then served on her, that is not the end of the matter, because it is still open to her, for instance, whether for human rights or any other reason, to make an application to the court and say, I should not have to come and be cross-examined or be treated as an adverse witness. She will do that by invoking a witness privilege of some sort. And, my lord, that is a process that your lordships are very well aware of. It's a process that was described quite fully in the Supreme Court in a case called Chachikata against the Republic. 2011, one Supreme Court law report at page 1. And the Supreme Court there goes into the issues of how a particular witness raised a claim of privilege and how it was dealt with in the courts below, and the Supreme Court then deals with that. So we are clear in our minds that indeed it will be within her rights. I mean, protection against self-incrimination or whatever it is, it would be up to the witness to make that claim and put it before the court. And naturally, the court would, as happened in that case that I have referred to, the court would hear what we have to say. In that particular case, the lower courts actually allowed the witness a privilege, or an immunity rather, an immunity in that case. And the Supreme Court overruled the lower court and said that that claim of immunity was not well grounded. So it will be open to her to take whatever step she felt appropriate. But my lords, in our respectful submission, This is a witness who, in fact, has every reason to accept a subpoena and to come and testify in order to vindicate herself and her role. This is a witness who has every reason to do that. Of course, it's her judgment as to what step she takes, but I wish to submit respectfully that this is a witness who has every reason to vindicate her role and her office by coming to testify in these proceedings. My lords, as we have previously indicated, this is a witness who gave glory to God for what she was doing. Appropriately, in our view, it would honor that God that she gave glory to in making her purported declaration, if she would come forward as a witness of truth.
Yes, the application.
My Lord, the statement I make is I would honor that God if she would come forward as a witness of truth.
But Mr. Chigata, you know the exercise has a purpose. Everything we do in court must have a purpose.
Yes,
and
excuse
me please, must have a foundation and must have a premise, must have a purpose, must have an objective.
Yes.
So our only interest, and when you talk about speaking the truth, etc., at large, our interest is the focus direction. And what is your focus direction? That's what we are interested in. But you don't think we should be interested in focus direction?
Milady, it is not at all at large.
All right.
Because, milady, in these proceedings, counsel for the first respondent, obviously on the basis of instructions from her, has challenged the truth of witnesses that we have put forward and the account that they are giving of interactions with her. Counsel has challenged the truth of what those witnesses are saying. In particular, in the case of PW2, Dr. Crystal White, counsel incessantly put to him that the accounts that he was giving of why they left, why he and PW3, Mr. Metonunu, left the premises had to do with instructions that they received from her. Counsel challenged this. Counsel challenged the truth of what the witness was. The witness several times had to say, but why would we leave our bags there? Why would we do that? You know, if this was not the case, why would we do that? And counsel for the first respondent put to him that he wasn't there in the meeting. Then we had Mr. Metonunu also come to testify. So, my Lord, the truth of what happened in terms of these interactions that took place on the 9th of December before the declaration, the truth is essential. And it would honor the God that she serves and she glorifies if she would come and testify as to the truth. That's what we're submitting.
Can we just limit ourselves to the affidavit? Let's limit ourselves to the affidavit in support of your application. Limit ourselves to the affidavit. Let's limit ourselves to the affidavit.
In the affidavit, we have made quite clear that this truth is very crucial. We've made it very clear.
But as to the God that he serves and all that, I think that we should not.
My Lord,
I don't think it is appropriate.
Lord, that was in a declaration that we can all take judicial notice of. I mean, and I do not say that in a light vein. I do not say that in a light vein. I say that actually in a vein of solidarity with giving glory to the God that she serves. I say that in that vein, not lightly at all. And I say that that God is a God of truth. And it would honor that God if she would come forward to testify to the truth. And my lords, in the affidavit, in paragraph 21, furthermore, in the proceedings to date, counsel for first respondent has challenged the testimony on oath of my witnesses, including testimony provided by PW2, Dr. Professor White, Dr. Michael Professor White, that Mrs. Jinadukwe Mensah had in a meeting with PW3, Mr. Robert Joseph Metununu, who also testified as PW3, sent the two witnesses who were serving as my agents at the National Collation Center, popularly referred to as the Strong Room, to go and deliver a message to me, with the promise that she would have a dispatch rider go and escort them back before she would make a declaration. My lord, that's a matter on which that's a matter on which hearing her address the truth of that is important, because as the affidavit goes on to say in paragraphs 22 and 23, counsel could only challenge the witness's testimony.
I want the specific paragraphs you are.
Paragraph 21, and then now I'm moving to paragraph 22 and 23.
I thought you stated earlier that the process should be divided into two, and that at this stage we are really dealing with whether the petitioner should be granted leave to reopen his case. I think it would be advisable if we stick with that one. If that is granted, then we could deal with the issue of subpoena and the truth and all of that. So I think it would help if we stick with the distinction that you yourself drew earlier. We should limit this to whether or not you should be granted leave to reopen your case.
My lord, I am grateful for that indication. Suffice it to say that I moved a little bit beyond that premise, the issue of the discretion, the basis on which your lordship will exercise the discretion. And so we have, in all candor, to put before you what we are going to do if you grant us a leave. That's the only reason. And then when the issue of...
I think
that's sufficient. Very well, very well. My lords, we will be guided by... And I mean, I'm pleased to see that I agree with the distinction that I made in the first instance. Because, my lord, indeed, my respectful submission is that at this stage, there is a sufficient basis from the circumstances arose on, I believe, our case. And when there was expectation that the chairperson of the first respondent would actually come and testify on behalf of the first respondent. And my lords, I believe it goes without saying that on that day, your lordships, the Chief Justice himself, expressed some surprise at the turn of events, and for that reason asked us to come back the next day in order to address your lordships fully on the legal issues that arose. So, my lords, taking the cue, I now proceed to respond to the affidavits in opposition that were filed apparently yesterday with some Valentine's Day messages to us. And my lords, in the affidavit of the first respondent in opposition to this motion, it is my respectful submission that there is unfortunate confusion as regards what the issues in this application are. That confusion includes claiming that we are here trying to review or appeal against the ruling of the 11th and so on. My lords, we are not here for that purpose. We've intimated that we are filing a review application as well, and we are within our rights to do that. But we are not here for that purpose, as suggested. And there are various claims which I do not wish to go into, because claims about vested rights, which your lordships pronounced on, and so on, which, frankly, are wrong. Your lordship did not, to my hearing, talk about vested rights, and I've gone over the ruling several times. But, my lord, the most startling passage in this affidavit in opposition is a passage in which the chairperson says something to do with disqualification. My lords, I wish to quote the exact words of that passage. Yes, that's what I want to refer. That's what I wish to refer to. My lords, this is paragraph 24. Paragraph 24. Again, I am advised that a subpoena is issued to a person, not to a party, to testify for the party on whose behalf it is issued. First respondent is a party and disqualified, and so am I. We take it a bite at a time. First respondent is a party and disqualified, and so am I. My lords, the rules about qualification to be a witness are provided for in section 58 of the Evidence Act, as well as section 59. Section 58 reads quite simply, except as otherwise provided by this decree, every person is competent to be a witness, and no person is disqualified from testifying to any matter. My lords, I shudder to think where she got her disqualification from testifying as a witness from. First respondent is a party and disqualified, and so am I. My lords, Section 58 does not make that possible. Section 59 goes on, and that is a section about disqualification. So perhaps we can look for some guidance. A person, 59.1, a person is not qualified to be a witness if he is A, incapable of expressing himself so as to be understood, either directly or through interpretation by one who can understand him. I don't think we have any doubt that the chairperson is a person who is very capable of expressing herself so as to be understood. Then B, and I just read the beginning again. A person is not qualified to be a witness if he is B, incapable of understanding the duty of a witness to tell the truth. My lords, if any witness or anybody wishes to rely on that on behalf of the chairperson, they are welcome to do so and to claim to this court that she's incapable of understanding the duty of a witness to tell the truth. But these are the disqualifications mentioned in Section 59. The final one, which is 59.2, a child or a person of unsound mind is competent to be a witness unless he is disqualified by subsection 1 of this section. So even a child is competent to be a witness unless disqualified under those provisions. So, my lords, I cannot imagine what this basis of disqualification that is so brazenly thrown in our face in paragraph 24 is about. And it goes on even more remarkably. A person subpoenaed is punishable by committal. What does that mean? I mean, a person who is subpoenaed is not punishable just by being subpoenaed unless they don't tell the truth. If they don't tell the truth, then of course they may face some consequences. And then finally, I am advised that the decision of this court renders a proposed subpoena irrelevant. My lords, with the greatest respect, my lord, not only is it a question of law, the point I'm making is that those claims about committal and so on, they arise in the second stage that we are talking about, in the second stage, not at this stage. And therefore, your lordship should not countenance what is in the affidavit.
Mr. Chikata,
yes.
Is it your proposal that we should rule on this quote-unquote first stage before you submit your you bring your submissions on the second stage?
No.
Is that your proposal?
No, my lady, that is far from my submission. My submission is quite simple. We are asking.
So you are presenting everything, are you not? You are
to the extent that I'm guided also by the...
Because you brought an application, and we must give one ruling on the application.
Absolutely. I don't expect more than one ruling. And all I'm saying respectfully is that I'm also guided by the cue from the bench that there's there's no need perhaps to go into all the issues related to the exercise of your discretion to the extent that they have to do, with what the testimony is going to be about. I mean, I take that point, that in terms of what the testimony is going to be about, it would not be appropriate for me to start going into all the details related to that, even though they are going to be important, and they are important parts of your exercise of discretion, but we have set them out in the affidavit sufficiently, and I decided I will not go into that into too much detail out of deference to the cue from your lordship. So, my lord, I'm not expecting two decisions. I'm fully expecting that there will be one decision, and I'm saying with the greatest respect that if that decision enables us to reopen our case, what we intend to do is to file a subpoena. That is all. That is basically, what brings together the two elements of what I'm submitting, that we will file a subpoena. And at that stage, whatever ground of disqualification she wants to bring forward would be a separate matter. I cannot be arguing about the ground of disqualification at this stage. I just draw attention to the fact that in her affidavit in opposition, she seems to be talking about some ground of disqualification which is not consistent with the laws of evidence of this country. Now, before moving on to the affidavit in opposition filed by the second respondent, I am bound to draw your lordship's attention again to just a couple more paragraphs of the first respondent's affidavit in opposition. That's paragraph 23, where she says, I am opposed to the petitioner being granted leave by this honorable court to reopen a case that he closed of his own volition and without compulsion. I am advised that even if this court grants leave for the petitioner to reopen his case, it ought not cause a subpoena to issue against me because a subpoena is issued with coercive effect. Again, this is a total misapprehension of the operation of Order 38 Rule 10, because we are not asking you to cause a subpoena to be issued against her. That's not what we are here for, as I've stated quite clearly. All we are here for is to ask for us to be allowed to reopen our case. And my lords, in paragraph 17, the chairperson says, the petitioner entered into the contest herein, believing that he would testify if need be. It became clear too soon that the petitioner's case drifted into departures from the strong room by the petitioner's agent of his own volition and grievances that I had served tea without biscuits to the petitioner's agent who had left the strong room to be in my secretariat. Well, I mean, the evidence in question came from cross-examination by counsel for the respondent. And to talk about grievances of being served tea without, my lords, respectfully, that is such a lack of truthfulness in terms of how the evidence came in. PW3 did not express a grievance that he had only been served tea and not biscuits. PW3 did not express a grievance. He was out of question, and he answered very truthfully Yes, I will serve tea, but there will be. But my Lord, for the chairperson to descend into such triviality, which was brought on by cross-examination of her own counsel, that just shows the depths to which she has sunk.
My Lord, the greatest respect.
Excuse me. Mr. Chikata, the practice is that you lawyers draft affidavits for parties, deponents in general, whether it's a party or whoever, yes, in applications. So please don't let us go that far. It may be councils.
Beyond that, Mr. Chigata, I would advise that you withdraw that statement. It's not.
My Lord, I withdraw the statement about the debts to which he has sunk. I withdraw that statement. And in place of that statement, I would respectfully say, very well. My Lord, just to say that a paragraph like that does not suggest an adequate understanding of the issues which we raise in this application. Just to say that, and I'm sorry that I used unduly strong language. And I apologize to the person of the chairperson of the first respondent. Now, my lords, my point, however, is that this affidavit of the first respondent rather than seek to offer your lordships a reason why you should not exercise your discretion to allow us to open our case, this affidavit only resorts to attacking our case, unfortunately. That is all it does. And I need not read any more passages to make that point. But I just draw your attention to that and avoid being provoked into comments that will get me into trouble. My lords, the affidavit in opposition, that second respondent, has also filed, is from Kweku Esifi, a lawyer. And my lords will see that in paragraph 12, the deponent says the instant application does not raise any new matter of relevance which could not have been discovered by diligent effort and so on. All the, my lords, this is not, we're not asking for leave to adduce fresh evidence. That's not the purpose of this application. In the sense that, we're not asking to adduce fresh evidence in the sense that you do in an appeal scenario, where as a matter of discovery of new facts, you put before the Court of Appeal that we have found new facts and we're coming. That's not the nature of application. The nature of application is, very precise. It is to reopen our case on the basis that we acted on the basis of certain representations. In our view, the chairperson of the first respondent was not even entitled to resign from those representations, but she appears to have done. And we are simply saying that we wish to reopen our case for the purpose that we have intimated to this court. And my lords, it is our respectful submission that the first respondent and his chairperson should in fact be the people who, on account of a community of interest with the Constitution of the Republic, would jump at the opportunity to come and give an account of their stewardship. The first respondent and its chairperson should be the ones who would want the world to know that they exercise their stewardship in accordance with the Constitution, by reference to due process, because there are allegations of lack of due process. And there is even evidence from cross-examination by counsel for the first respondent. There is evidence that he brought in about vote padding, for instance. There is evidence which he brought in about material on the pen drive that was in evidence from the petitioner's first witness, which testified to vote padding. Now, my lords, indeed, before I conclude my submissions, we respectfully would ask that we play the videotape which we have put in evidence of Mr. McMenu indicating very clearly that in his view, not in his view, just indicating very clearly that when they come to court, there will be testimony about vote padding in favor of the petitioner. Now, the reason why this is really rather critical is because we would imagine that this chairperson of the first respondent would want to disabuse the minds of the people of Ghana of any suggestion that there have been such grave malpractices in the context of the election that she supervised. And my lords, we have her testimony. Well, I'm sorry, not her testimony. We have, because we don't have her testimony yet. We have her counsel putting to a witness. And my lords, clearly, when counsel or counsel puts something to a witness, it must come from your instructions. Otherwise, the counsel is acting unprofessionally. That's what our rules say. So when her counsel puts evidence of vote padding and gets confirmation from a witness of that evidence, well, this is a serious matter because it affects the whole issue of the rights of voters to have a credible election with results that are declared in accordance with valid votes and all that. And yet we had that situation where counsel put to the witness. And counsel did not only put to the witness those allegations of vote padding. Counsel put to the witness also allegations that for one regional coalition in Eastern region, there were 2 coalition chiefs. And counsel sought to go into that, which I will not go into. But my point, respectfully, is that counsel, in fact, in doing all that, counsel is really the one who has shown clearly the importance of the testimony of the chairperson to address these issues. My lords, we also had the testimony which showed, again in response to a question from the bench, which showed that the form which ostensibly, the Form 13 so-called, which ostensibly the chairperson had acted on prior to a declaration, was not in fact the form that is provided for in regulation in CI 127. That testimony was before this court. And my lords, it is respectfully only fair for the chairperson to have the opportunity to admit or deny that important piece of evidence which came from PW2 in answering a question from the bench. It is therefore our respectful submission that none of the points made in the affidavits in opposition provide a justification for our not being allowed to reopen our case, and therefore that your lordships, in the interests of achieving substantial justice, as your lordships have often expressed, you allow us to reopen our case on the grounds that we have urged and for the limited purpose that we have urged before you.
My lords, we are opposed to this application to reopen the case of the petitioner. Lords, we have filed an affidavit in opposition, and Lords, we rely on the positions in the affidavit in opposition. My lords, this application has been filed following the ruling of this court on the 11th of February 2021. Lords, I believe that, therefore, Canada demands that the petitioner would, in deposing to the reasons, assign the appropriate reasons to the court. Lord, may I kindly refer you to paragraph 11 of the affidavit in support. In that paragraph 11, it is being alleged that the reason which the court gave was basically that, let me just read it. In respect specifically of the witness statement filed on behalf of the first respondent, the court decided that the court decided that since she had not been called as a witness by the first respondent for her witness statement to be admitted in evidence, she would give under oath she was not available to be cross-examined. Lords, I have read the ruling of the court. Nowhere did the court say what the petitioner has said in paragraph 11 of his affidavit in support. Indeed, my lords, what the court said was that, with your kind permission, simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondents to enter the witness box to be cross-examined. So the reason the court gave is that the petitioner is attributing another...
Mr. Menuvo,
yes, ma'am.
You cannot cross-examine a person who has not testified in chief.
Pardon me?
A person who has not testified in chief cannot be cross-examined.
Yes.
And this person had not even testified in chief.
Yes, your ladyship, but the point I'm making is that a reason is being assigned by the petitioner
I appreciate the point you're making. What I'm saying is that it seems to me to be a strange argument, because you cannot even talk about cross-examination when there hasn't been an examination in chief.
Your ladyship, where a supplicant, an applicant before the court, makes false statements to support his application, I believe that it is only fair that counsel will point out those false statements to the court. That is my submission, that the court assigned reasons in its ruling of 11th of February, and it shouldn't be what he has said in his affidavit in support.
My lords, I do not think that it can be claimed that we made a false statement. My lord, there is an account given of your ruling. Counsel is entitled to give a different account. Ultimately, it is for your lordship to determine whether what we have said. But to say it's a false statement that we have made in the affidavit, that, my lords, is not acceptable.
Well, I will draw the word false. It is an incorrect statement. My lords, yes, my lord. My learned friend was saying that my choice of word false. Yeah. That is why I said it is an incorrect deposition. Deposition, I get the correction, my lords. My lords.
Or it doesn't reflect what?
Yes, ma'am. Yes. Lords, a perusal of paragraph 13 and 14 again creates the impression that the court ruled in those matters that's in the review, in the interrogatories, on the basis that the first respondent chairperson will be available to be cross-examined. Lord, again, with your kind permission, regarding the ruling of the 11th, this is what my lordship said when that argument was made. We are also of the opinion that the filing of affidavits in interrogatory applications with the position that the deponent will be available for cross-examination does not make the deponent compellable to adduce evidence at the trial. As already stated, learned counsel for the petitioner only referred us to an affidavit deposed to by the chairperson of the first respondent in opposition to an interrogatory application to serve interrogatories. That affidavit is not evidence in this petition to enable us compel the first respondent to mount the witness box. So, again, my lords, on the 11th of February, the court was very clear in its ruling. Now, my lords, in paragraph 16, the petitioner deposes that representations were made by me, or for that matter, the first respondent's chairperson to him. Lords, I think that that is a very unfortunate statement, simply because the petitioner decided on his own to take the steps that he has taken in this matter. The petitioner, first of all, did not obey earlier orders of the court. And then when he obeyed the orders, he filed 2 witness statements. And then the petitioner subsequently sought leave of the court to call a witness. Then the petitioner decided that in spite of the fact that I had intimated in my petition that I was going to call 5 witnesses, I am limiting myself to 3. I closed my case. How petitioner will now see to say that it is as a result of misrepresentations that were made to him that he closed his case, I cannot phantom.
My Lord's respectfully, I never said misrepresentations made to me. I never said misrepresentations.
Yes, Lord. Lord, he said representations. I corrected to representations. Lord, again, paragraph 20 of the affidavit in support refers to a matter that this court ruled upon on the 11th of February 2021. This is what the court said on that. That is so, my Lord. Paragraph 20, where
Constitutional rule, the first respondent, please.
yes,
Are you not talking to via paragraph 20?
yes, said my Lord. That paragraph 20. Yes, Lord.
Constitutional rule.
Yes, my Lord. And my Lord's ruled on it, made a pronunciation on it. That was just going to.
You see, this application is not for review of the decision. Technically, in all substance, it is not for review. The case has been closed by both parties, and they are seeking the leave of the court to reopen. If I understand what the motion stands for.
Yes, my Lord.
Yes, so please address it. This is paragraph 20 is just the constitutional rule.
Very well,
the first respondent
my Lord.
is deemed by law to play.
Yes.
You can well, it's your case, but I think it's better maybe place emphasis on it.
Well, my Lord, with respect, I move on. May I refer your lordship to... Yes, my Lord.
I think what my Lord, the Chief Justice, is saying is address us on why the petitioner should not be allowed, not be granted leave to reopen his case. That is what we want to hear from you.
Yes, my lords, I will come to that. But for example,
you are taking too long to get to that. That's what interests us.
Well, so my lords, I take it that the paragraph 25, which is an untruth about what happened regarding pen drives. I think that in fairness...
you see, just like I drew Mr. Chikate's attention to, we only function with law here. So, first, my Lord Mafusa asked him what rule he was coming under. Then I asked him the grounds on which he wanted us to exercise our discretion. These are the things that we are interested in. So when you oppose it, tell us why we cannot grant this application or should not grant this application. And then the cosmetics can be dealt with later.
Well, my lords.
You see, you have spent some time seeking to attack the depositions in the affidavit in support of this application. Yes.
Well, my Lord, I will move on. Lord, it is my submission that this application is not warranted by any rule of law or by procedure. And my lords, this court is primarily not a trial court, and therefore we may borrow from Rule 5 of CI 16. And Lord, if we borrow from Rule 5 of CI 16, the closest, yes, my Lord, Rule 5 of CI 16, which permits the court to go and look elsewhere. Lord, the closest that, yes, my Lord.
If not a settled practice that a case can be reopened in appropriate circumstances.
My lords, it is a settled practice, but there are circumstances.
Yes.
And so, my lords,
go there. That is what we want to know. They have argued at length that they want to reopen the case, and it is permissible in law. So you satisfy us in opposition why the application ought to be refused. Because this application technically is directed against you.
Yes, my lord, with respect.
They also close their case. They have, I'm talking of the second respondent, they also have a role to play. But they are not suggesting in the list that the case is reopened, they are going to serve the second respondent to come from the Jubilee House to give evidence.
Yes.
Have they said so?
My lords, well, I take a cue. My lords, the view I hold is that if I appear before the Supreme Court,
the court which is inviting you to address us on some material which is agitating our mind.
Yes, my lord.
Yes.
My lord, so I will plead with your lordships to refer to a high court decision, which I know is not binding on your lordships, but with the greatest respect, it will help throw light on the circumstances under which a court will permit a party to reopen a case. My lords, may I refer your lordships to the case of Annobile versus Obosu and another, 1982-83, Ghana Law Report, Annobile versus Obosu, OBOSU and another, 1982-83, Ghana Law Report, 585. Lord, in that case, there was an application before Osefri J, as it then was. Lord, this was to reopen a case after the parties have closed their case. Now, His Lordship, in deciding whether or not to grant the application or refuse it, relied on the case of Young versus Kershaw. Young and the versus Kershaw. Kershaw, Kershaw, and Burton versus Kershaw, consolidated. (1899), 81 LT NS 501 at page 532. The Court of Appeal of the English courts, which Osefri relied on. With your kind permission, my lords, I read. It is a matter of greatest importance and has always been so treated by courts that all material evidence which could, with reasonable skill and diligence, be produced at the trial shall be the only evidence which can be considered and must be adduced at the trial. It is obviously in the public interest that parties who have gone through the ordeal of litigation and have had their rights settled at the trial should not afterwards be allowed to patch up the weak parts and fill up the omissions in their case by means of fresh evidence. It is true that in special and exceptional circumstances, a new trial has been granted because new evidence has been discovered. But the rule which permits that to be done is fenced round with many limitations. The party asking for the new trial must show that there was no remission on his part in adducing all possible evidence at the trial. Then again, as to the class of new evidence, the rule is that the new evidence must be such that if adduced, it will be practically conclusive. That is, evidence of such a class as to render it probable, almost beyond doubt, that the verdict will not be different. And so, my lords, it's my submission that just as in Young versus Kershaw, this petitioner, with very competent legal representation, elected of his own volition to close his case, this should not afterwards be allowed, he should not afterwards be allowed to patch up the weak parts and fill up the omissions in his case by means of fresh evidence. And the only reason is that I wish to call the chairperson of the first respondent, who is the adversary, into the box by way of subpoena. My lords, this whole process that has been filed is an abuse of the court processes, my lords. Lords, with greatest respect, I have gone and done a bit of research all the way back to 1876, when we received the common law in our jurisdiction. I have not come across one case where a party closes his case and then he is seeking leave to reopen the case only because he wants the adversary to enter the witness box for him. My lords, it totally will collapse our adversarial system. My lords, we ask ourselves the question, assuming that this application is granted, does that mean that the court will now open the floodgates for the first and second respondents to give rebuttal evidence? My lords, it is just going to abuse the process, and it does not augur well for the determination of this matter, a specific matter under Article 64(1) of the Constitution and CI 99. My lord, for example, the motion is titled an application to enable, if I got it right.
No, it says motion of notice for release.
Yes, my lord.
A court of record.
Yes, I'm coming to read it. It says motion of notice for leave to recall the case of the petitioner to enable the reopen the case of the petitioner, to enable the chairperson. My lord, the key word is enable the chairperson of the Electoral Commission to testify. My lord, this alone, the title alone of the motion, should be a ground for a refusal of this application on grounds of abuse. My lord, well, the body says something else. He says that upon serving a subpoena. Lord, I believe that if I refer your lordship to Order 39, Rule 5 of the High Court Civil Procedure Rules, CI 47, the rules attach pain of punishment, among others, where a subpoena is served and you don't take certain steps. So, my lords, I believe that the depositions in the affidavit in opposition with reference to a subpoena, it's my submission, were right. Lords, there has been a submission which is to the effect that the way I cross-examined the first witness of the petitioner, I could only have gotten information from the chairperson of the first respondent. But my lords, if you go through the record, I used the witness's own exhibit D and E to make my analysis, and he admitted saying, and Lords, regarding the evidence of the second and third witnesses of the petitioner, Lords, what they said, how they contradicted themselves is on the record. So the issue of the two different stories are for the court to determine. Very well, my Lord. Lord, I'll be ending soon. My Lord, I wish...
It's your time.
Yes, my Lord.
You are not even allotting time for counsel to be so, limited to within a very short time to present the submissions.
Yes.
So please, try and organize yourself and present your case. That is all.
Yes, my Lord. I have addressed you on the abuse of process, and then I just wish to end my lords with the fact that a person summoned on a subpoena testifies in court as the witness of the party who caused the subpoena to issue. This application does serve as notice to your lordships that your court will be required to issue a subpoena for the first respondent to testify as a petitioner's witness. Again, my lords, it confuses our adversarial system of adjudicating.
If Mr. Chikata said the person will be an adverse witness.
Yes, but your ladyship,
hostile.
Yes, but definitely it is a party that calls a hostile witness.
So, Mr. Manugo, can you address us on section 26 of the Evidence Act,
Yes.
which was argued by...
Stop here.
Yes. My lords, with respect, section 26 does not arise at all. Lords, if you go to section 24, it says that where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action, no evidence contrary to the conclusively presumed fact may be considered before the tribunal of fact. Then it is juxtaposed with section 26. It says that except as otherwise provided by law, including a rule of equity, where a party has by its own statement, act, or omission intentionally, deliberately caused or permitted another person to believe in a thing to be true, etc. Lords, a combined reading of these two do not support the petitioner's case one whit. My lords, what are the presumed facts in this matter? The presumed facts, so far, the petitioner has been silent on. All he says is that, I didn't anticipate that the first respondent will close his case, and therefore, I think that there are matters that will support my case, and therefore she should be called. That's it. It has nothing to do...
If I heard Mr. Chapter right, the presumed facts are that, one, in your statement of case, you alluded to the fact that the chairperson of the first respondent, we will make it available for cross-examination, that he will testify. And then the other one was the affirmation in the position where she indicated to be available.
That was why I was referring your lordships to the various rulings on the court that are determining the matter, but my lord said I should go to the sub. So it's my submission that the various ruling by the court for interrogatories, review, discovery, they have all addressed the matters that he is raising. That's my submission. Lords, on a lighter note, God is a God of conscience. My Lord, I believe that.
Ask him to go that far. It is in the court of law.
Yes.
Yes.
But my Lord, with respect, with the greatest respect.
When we come here and we take the oath and we swear on the cross or on the Bible, so be it. Yes.
My Lord, with respect, may my counsel for the petitioner consistently made statements attacking the faith of the chairperson of the first respondent.
We corrected him. I think we corrected him that we are not here to demonstrate the faith of parties and witnesses.
My Lord. Yes. Yes. Lastly, it is my submission that no representation has been made whatsoever to the petitioner for which, based on that, he is bringing this application. Because I don't think that it is fair for the petitioner to blame the respondents rather than himself for the reason why his action had taken the stages that it took. Lords, I repeat that the first respondent is vehemently opposed to this application and prays for its dismissal. My Lord, I'm grateful to the court.
As I said, the application is directed basically against the first respondent. But since you were served.
Yes, my Lord, and I believe that the ruling of the court on the application
it will affect the case in general. That is why you want to
materially our position in this matter. So we are entitled to give a full response to the application. My Lord, I wish to make a preliminary observation, submission, which is that ours is an adversarial system of litigation. It is not inquisitorial. Secondly, in that system of litigation, the question of burden of proof and the burden of producing evidence is fundamental. It's one of substantive law. And therefore, a party that bears the burden of proof and the burden of producing evidence, as the petitioner undoubtedly does, must effectively meet that burden of proof. And Lords, it is well established that where the party bearing the burden of proof and burden producing evidence fails to meet these two burdens, the court has every right to dismiss the party's plaint, because the party's reliefs can only be obtained if it leads evidence that meets these two burdens. And it's our submission, my lords, that to date, the petitioner, in our respectful view, has failed woefully.
Are you addressing this?
No, my lords.
You are making a general, don't go there.
My lord, I'm setting a foundation for my specific arguments. You know.
These are general propositions of law.
Yes.
Yes. And credit us with that knowledge of the law.
Very well. My lord, I wish to rely on my depositions, the depositions in the affidavit of second respondent in opposition to the petitioner's motion for leave to reopen the case. All the depositions. And my lords, particularly, I wish to refer your lordships to paragraph 12, paragraph 13, paragraph 14, 15, 16, and 17. My lords, it is our view that the general principle of law is that once a party to a suit announces to the court that he has no additional evidence to adduce and thus closes the case, the court is obliged to affirm the decision of the party. And my lords, we wish in that respect to refer your lordships to Lai versus Oforiwa, 1984-86, 2 Ghana Law Report, 410 at 427. And that's a court of appeal case, Oforiwa, 1984-85, 2. 1984-86. My lord, it's 84-86. 2 Ghana Law Reports, 410. A court of appeal case where at page 427 the court held that the learned counsel submitted that the trial was unsatisfactory, for the learned trial judge closed the case for the defense when the cross-examination of the defendant's witness had not been completed. I think this is not a fair criticism of the learned trial judge, for the record clearly indicated that it was the defense counsel who announced to the court that he was not calling further evidence. He was closing his case. In the circumstances, the court could not do otherwise but to accede to the request of the learned counsel and close the case for the defense. Counsel for the defendant contended that in any case it was wrong on the part of the counsel who appeared in the court below to have closed the case of the defendant at that stage simply because the witness was not available for further cross-examination. But it seems to me that the learned counsel in the court below acted wisely and in the best interest of his clients, and that any counsel placed in the situation in which would have acted in similar manner. And Lord, it is our submission that it was counsel for petitioner who voluntarily announced to the court that he had closed his case. Lord, he did so taking note of all the evidence adduced by witnesses and through cross-examination of witnesses. My Lord, that evidence included what happened in the strong room. The evidence also included the alleged conversation between the third witness of the petitioner and the chair of the first respondent, and it also alleged irregularities in the collation of results. And the petitioner led all the evidence that he had in proof of these allegations through the three witnesses. My Lord, he cannot, having led evidence that was within his knowledge or that he could have, by exercising due diligence, obtained, now come back after closing his case to apply to the court to reopen the case simply to lead further evidence on the same matters. My Lord, the petitioner also led evidence on what he considered to be unconstitutional actions, lack of transparency and fairness by the chairperson of the EC. Evidence was led on all these things. My Lord, so the question is, if the case is closed and the respondents elect not to adduce further, enter the box and adduce evidence, the question then is for the court to look at the evidence before it and determine whether or not the petitioner has led evidence to meet his claims and reliefs. And my Lord, it is important to underline the point that this has absolutely nothing to do with why the first respondent's chair does not want to enter the box. It is a totally irrelevant question at law. It is totally irrelevant. Again, it has nothing to do with the suggestion that the first respondent's chair must be pleased to have an opportunity to vindicate herself. But these matters are completely irrelevant to the application to reopen one's case and lead what in effect is fresh evidence. Because the idea is to reopen the case, subpoena the first respondent's chair so that he can lead further evidence. That is new evidence. And my lords, it is our respectful view, that the petitioner is bound to meet the time-tested conditions established by this court to lead new fresh evidence. He cannot hide behind the application to reopen so as to subpoena, to suggest that this is not in substance an application to adduce fresh evidence. And if it is, as I think it is, then he must meet two basic conditions. One, that the fresh evidence that he is seeking to adduce through the subpoena was not available and could not have been obtained through due diligence. It's a submission that the proceedings of this court show clearly that the evidence on these four matters, what happened in the alleged encounter between the chairperson of the first respondent and the second and third witnesses of the petitioner, what happened in the strong room, the allegations of irregularity are clearly before this court. So it cannot be fresh evidence. Secondly,
Fresh evidence. Please look critically at the motion.
he's seeking to reopen the case.
That's right.
So that he can subpoena. My Lord, and that is why, my Lord, with all due respect, that is why I think that the substance of the content of what he intends to achieve through the subpoena must be assessed, evaluated by this honorable court before it can decide whether or not to exercise its discretion in granting the application to reopen.
Yeah, I think, Mr. Jesse, we heard him. Sorry, Mr. Kutampa.
My lords, my good friend, Mr. Chachikata referred to me as my friend Sheshe in the course of these proceedings.
You see, I think he made a point that they want to reopen their case so that they can serve subpoena on on Mrs. Jane Mensah, so that she can be treated as a hostile witness. Yes. So address that, please.
My lords.
Dr. Tampa, whilst you're addressing it, I also understood from him that you did some harm in cross-examination. You brought certain things out in cross-examination. So he should be allowed to speak to that through the process of the subpoena.
Yes. My lord, our case is that at the time he was electing to close his case, he knew, the petitioner knew these new matters that were elicited from his witnesses were matters of record. And if he really intended to do that, he should have applied to the court to enable him to lead, to file a new witness statement, to lead evidence on that. He didn't do so. He had all the information at that time, and he boldly declared to the court that he was closing his case. The only reason why now the petitioner is applying to reopen his case is because after he closed his case, the respondents exercised a right that they had not to adduce any evidence. And my lords, counsel for the petitioner and the petitioner cannot say that they did not have an inkling of an idea that this was a possible approach that the respondents would adopt. First, because it is a process that is available in any trial for defendants.
Second, Mr. Kotompa, look at paragraph 16 of the affidavit in support. They said they were taken by surprise.
Yes.
By that year.
Yes,
it therefore came as a surprise.
Yes.
That both counsel for the respondent announced on Monday, 8 February 2021, that this was no longer the case. This was no longer the case. Paragraph 16 of the affidavit in support. Which means they had prepared to cross-examine your witnesses. And that was why they closed their case.
Yes.
They had no inkling whatsoever that you were going to close your case.
Yes.
And then this matter came to them as a surprise.
Yes. My lords, if I may respond to that. My first point is that if they had thought through fully the case of the respondents, they would have known that this was very likely to happen. Because right from the beginning of our filing our answers, we had served notice to them and the court, but we didn't think that we had any case at all for us to be even heard. And yet, this honorable court, in its own wisdom, directed that you would deal with our preliminary objection at the end of the trial. So, they must have had notice that it was likely, if they failed to lead sufficient evidence, that we will not adduce any evidence. And consistent with our original and primary position, we would ask the court to determine the matter on the evidence before it. So, it is, I cannot believe that my learned friend, Mr. Chachikata, would not have anticipated this matter as a matter of strategy. He should have, and if he didn't, well, my lords, that would be too bad for his client.
Mr. Kotambo, if I recall, your submissions are already on file, aren't they? Your preliminary objections?
Yes.
They're already on record?
Yes.
Everybody's?
Yes, they've been served. Now, my lords, so that deals with the surprise. And my lords, again, it cannot be the case that they were relying on the statement made by chairperson of first respondent that even if the interrogatories fail, they would have an opportunity during cross-examination. My lord, that cannot be, as I've earlier stated, cannot be a commitment to the fact that we shall lead evidence to the chief. It is only a legal argument that you may have that opportunity during cross-examination. And that opportunity will arise only if you enter the box to lead evidence in chief. So it can never constitute a fact under section 25, 24 of the Evidence Act, upon which they acted to their detriment, and therefore we are estopped, or the first respondent is estopped from exercising his right not to adduce evidence. It cannot be. And my lord, what is even more interesting is that those provisions of the Evidence Act, my lord, we see that section 24 that he reads says that conclusive 24(2) reads, conclusive presumption include but are not limited to those provided in section 25 to 29. And my lords, if one goes to 25(1), it says, except otherwise provided by law, including a rule of equity, the facts recited in a written document are conclusively presumed. Again, in 26, it said, as otherwise provided.
That's on 24 and 25 deals with the contracts and conveyance.
Yes, but my lord, I'm saying that you will see these provisions must be read as a whole. You cannot take this out because section 26 again repeats the except as provided by law, could be a real evidence. When a party has by his own statement, act, or omission, intentionally or deliberately, caused or permitted another party to believe a thing to be true, and to act upon such belief, the truth of that thing shall be conclusively presumed. So there are exceptions in law and in equity. So it is not, and the same goes for section 27, 28, and 29. So, my lords, I think that it is misconceived for counsel for the petitioner to suggest that the conclusive nature of the alleged statement of fact by first respondent is not limited in any way. And it is, in our view, limited by the right of the respondents to elect not to adduce evidence. My lords, again, we wish to refer your lordships to the case of the president of the Methodist Church of Ghana versus K spelled K-Y-E, K-A-Y-E. Now, the president of the Methodist Church of Ghana versus K. My lord, it's a judgment of the High Court Caicos by Owusu J, as it then was delivered on 10th April 1970. It's a one-page ruling, my lord. 10th April 1970.
Is it in the 1970 current cases?
No, it's actually in the law reports 1970, but we couldn't.
1970.
Yes. But we have
the current cases.
Yes.
Yeah.
Yes.
Okay.
So, my lord,
What did the judge say?
held. Once a party closes his case, he abandons every right to call further evidence, except with the leave of the court. Precisely, that's why I'm saying that this is an attempt to call further evidence. That is the point I'm making, my lords. You know, and he must be held to the rule or the conditions to be met in order to adduce fresh evidence or further evidence, to use his words. Such an application is only considered when at the time of closing the case, no human ingenuity could foresee the existence of the particular evidence the party is seeking to adduce. That cannot be the case in this situation, my lords. Again, my lords, we also rely on Honorable and Obosu and another, referred to by counsel for first respondents. And again, my lords, refer your lordships to the case of Combat versus Lambin, 1989. Sorry, my lords. Combat spelled K-O-M-B-A-T versus Lambin, L-A-M-B-I-N, 1989, 91 Ghana Law Reports, 324, where Ben J, as it then was, at the close of Pretty's case, called a witness Somoto, who testified, where the trial court
was it the Benny J who called?
No, the trial court. The trial court.
This was his similar.
Yes. It was a trial court, yes. After the case of the plaintiff's case, the trial court called a witness, Somoto, who testified in support of the defendant. And based on that testimony, the case of the plaintiff was thrown out. The plaintiff appealed against the decision of the court. The High Court, Quorum Benny J. Accident, was allowing the appeal, stated as follows. The general rule of evidence was that after a prisoner's case was closed, a judge should only call a fresh witness when a new matter had arisen ex improviso, which would not have been foreseen. Such a witness could, in civil cases, only be called with the consent of all the parties. My Lord, let me emphasize, with the consent of all the parties in civil case. My Lords, we believe that the authorities in Canada, a Commonwealth jurisdiction, common law jurisdiction, may, with respect, assist your lordships. And we wish to refer to the case of Ontario Limited versus Sagas Industries, Canada Incorporated. It's a 2001 SEC 59 or 2 SCR 98. That's the Supreme Court of Canada. There, the High Court approved of the two-stage test first articulated in the case of Scott versus Cook, 1970, OJ number 1487. Namely, the test which is intended to assist the trial judge in exercising his or her discretion to reopen the trial requires the moving party, one, to show that the evidence he or she seeks to adduce is such that if it had been presented at trial, would probably have changed the results. And two, prove that such evidence would not have been obtained by reasonable diligence before the trial court. My Lord, these are the same principles that this honorable court applies in adducing fresh evidence. Now, my Lord, it is our submission that this case is about votes and numbers. My Lord, there is nothing about the engagement between the second and third witnesses of the petitioner, alleged engagement with the chairperson of first respondent. Even if true, that has been shown to have had any material effect on the outcome of the elections. And we demonstrated that quite thoroughly during our cross-examination of Mr. Asiedin Ketia, where we took him through all the different stages to show that no matter what you do, first, second respondent cross the 50+ threshold, and petitioner persistently remained around 47%. So, and truth be told, the third witness actually declared during cross-examination why they were going to see the petitioner. What was it? They were going to tell him about the irregularities and errors in the collation process. Now the question is, does their claim of irregularities and errors in the collation process legally stop the EC and the returning officer of the presidential election from exercising her independent function and duty to declare election results if, in her view, the election results were accurate? The only thing that the petitioner could do would be to come to court to demonstrate that the election results were not accurate. So, my lords, one cannot fault the EC chair until you come to court and are able to show that the election results were not accurate. And
please address us on the general principles which you've based your submission on the authorities.
Yes.
The EC on record is not your client.
I'm a bit taken aback.
Reopening the case may have serious consequences on the case, because both of you may do so many things. But for the time being, yes, the application is for the reopening of the case for the petitioner.
Yes,
and your attention has been so much on the first respondent. And I'm saying that on record, they are not even saying that when the case is reopened, they will subpoena the second respondent to mount the witness box.
That's exactly what they said.
So we want you to address it on why the reopening should.
Very well.
Yes, I think you have to understand the bench.
Very well.
Yes, because they are not asking for anything from the second respondent.
Very well. My lords, my simple submission is that to reopen, they must satisfy the two preconditions. One, that the evidence they intend to lead was not available to them at the time they closed their case and could not have been obtained by the exercise of due diligence. Yes. And two, that the evidence they intend to adduce, if they are given leave to reopen their case, on the case. And they are saying that there's no way that it will have a material effect on the case, given the evidence before the court. Even if they use her as a voter witness. Even if they choose to use her as a hostile witness, my lords. My lords, we also wish to refer your lordships. My lords, we also wish to refer your lordships to the oft-quoted case of Dombo and others, versus now 1970 CC 68, a Court of Appeal case, and then
Fresh evidence on appeal.
yes.
Yes, this is not
But it
an
is
appeal. So the principles are never the same. Adduction of fresh evidence on appeal has nothing to do with reopening of a substantive case at the court. Yes, or to reopen it.
my lord,
Please.
my lord, the principles apply in pari materia. That is my submission. And the principles apply in pari materia. And my lords, 68, a Court of Appeal decision. And my lords, again, in Poku versus Poku, 2007-2008, 1996, Supreme Court of Ghana Law Report, 1996, 996, sorry. Now, my lords, it's our case that the decision of the court in Poku and Poku, even though referred to adducing fresh evidence on appeal, are the same in the case where a party closes his case and applies to reopen his case to adduce further evidence. They apply pari materia. And in that case, would CJ observe as follows at page 1015. Consequently, the invariable rule, as I understand it, is that in an application to lead fresh evidence or new evidence, the first criteria which an applicant ought to establish is whether or not the evidence sought to be adduced was not in the possession of the applicant party. or was not obtainable by the exercise of reasonable diligence or human ingenuity before the impugned decision was rendered. It is only when this first hurdle has been surmounted that the court should proceed to determine the other pertinent question of whether or not the intended evidence would have a positive effect on the outcome. Stated differently, if the first criterion is not met, no useful purpose will be served by examining the other factors. And my lords, it is our submission in respect, if I may make submissions on the question of subpoena, or it is not a matter before your lordship. My lord, it is our submission that the application of the 65 Rule 4 of the High Court rules, CI 47, states, Order 35, Rule 4. That's Rule 4. States thus, a writ of subpoena ad testificandum, or a writ of subpoena duces tecum, to compel the attendance of a witness for the purpose of proceeding in chambers may be issued out of the registry if the party who desires the attendance of the witness produces a note from the judge or register authorizing the issue of the writ. Further, Section 88(1) of the Evidence Act 1975, NRCD 323, provides in earlier that, except as otherwise provided in this part of, of Evidence Act 1975, states inter alia thus, except as otherwise provided in this part or in any other enactment, no person has a privilege to refuse when duly subpoenaed to the witness. Now, my lords, the petitioner applied to this court to open his case and to issue a subpoena to compel the chairperson of first respondent to testify. My lords, this should be viewed, this application should be viewed in the peculiar circumstances that first respondent has already elected not to adduce any evidence in this petition. And the court has affirmed its right not to elect or to adduce any evidence. My lords, the process of cross-examination involves adducing evidence. And so, my lords, it's our submission that the object of this application to reopen the case is precisely the object of their opposition to the respondent's election not to adduce evidence. And it is our respectful submission that the court, having upheld that right of the first respondent and the respondents generally to elect not to adduce evidence, cannot with one hand affirm that right and with the other hand disaffirm it by allowing the petitioner to subpoena him, to cross-examine him, and thereby adduce evidence from her. I think that would be inconsistent with the court's own ruling. My Lord,
Mr. Tuampa, based on the submissions you've just made,
yes.
What would be your comment on paragraph 15 of petitioner's affidavit in support?
Yes, paragraph 15, my Lord. Yes, my Lord, it's saying that it has become necessary. My Lord, we say that they have demonstrated absolutely no necessity. My Lord, the petitioner has demonstrated no necessity. Because, with all due respect, they have not shown how the grant of the application would have a material effect. That's the necessity. Material effect on the outcome of the matter in dispute. They have not shown it. All that they have said is that the EC has a constitutional role. It has to be accountable. The chair of the EC has to be accountable to the people. So, and your lordships in their ruling said that the rules that apply to ordinary people in these circumstances equally apply to the EC chair. That's what your lordship's ruling a few days ago stated. So, my lords, we do not see that they have demonstrated any necessity. All the necessity is based on the fact, the allegation that the chair of the first respondent is stopped from saying that he will not enter the box because she had already committed herself so to do. When the chair of the second respondent never ever committed herself to that and cannot thereby be stopped. My lords, we would with respect end with we will end with the two other cases. My Lord, the first is the Northern Ireland case of Ryan Andrew Fulton and Ms. Fulton and Cyril Fulton. Sorry. Ryan, R-Y-A-N, Andrew, and Fulton, F-U-L-T-O-N, and Ms. Fulton and Cyril Fulton. This is AIB Group, UK, PLC. 2017 NICA 42 or 2017 WL 03382220.
WLR or WL?
No, that's WL. L, that's all. Zero At page 5.
He said 0, the citation.
The citation is, the first one is NICA 44.
Oh, okay.
Yes, 44. My lords, this was a case where in the court below, the High Court judge refused an application for discovery because it did not satisfy the two important tests of disclosure, which are necessity and relevance. And my lords, in your ruling on discovery, you upheld these two cardinal principles, necessity and relevance. My lord, the applicant's appeal was accompanied in the case by an application for subpoena against various people, including counsel for the respondents, to produce discoverable documents. The court, per Gillian LJ, dismissed the appeal and disallowed the subpoena application, stating emphatically in its judgment thus: suffice to say that we are satisfied that the application in front of McBride J for discovery was correctly decided by her, and we affirm her decision. And this is the important statement of the law. Accordingly, we also come to the conclusion that there is no basis for the subpoenas now being sought, as they arise out of the claim for disclosure. If discovery is not appropriate, then subpoenas are not appropriate.
Mr. Akoto, what's the relevance of this case to the present application? You are now dealing with subpoena and discovery. We've gone past that. We are now dealing with an application invoking our inherent jurisdiction to reopen the case.
Yes. But the reopening, my lords, relate to the substantive issue of the matters they sought to elicit.
As at length on the reopening. But my brother is just asking you how that is best in affinity.
No, because my lord, there's a principle that a request for subpoena cannot be used to disguise an application for discovery. That's the principle of law.
No, come again.
A request for subpoena cannot be used to disguise an application for discovery of document.
No, but we've gone beyond discovery, and these are earlier interlocutory applications which we disposed of several weeks back.
Our understanding of this process in the circumstances of this trial is that they are seeking by their subpoena to elicit the very information that they failed to elicit in their application for discovery. And I'm saying that the principle is that what you cannot get by discovery, you cannot use a subpoena to get. That is the point, my lord. And my lord,
according to you, or according to them, their submission, you give them the promise that you don't need the discoveries. You don't need the discoveries because you'll be available to testify, and they can ask those questions when you are in the witness box.
My lord, with all due respect, we never made any promise. We just stated the position of the law that a matter that you may not obtain through discovery, you may elicit through cross-examination. That is all. I'm not saying that we promised to enter the box, because that time, the time had not arisen for us to adduce
Mr. Kampa, you did not make the promise. Yes, we on record, it is there. But yes, Because,
my Lord,
and more so, you are not appearing for the first.
yes, my Lord, yes, that is true. But
Is it free legal advice?
no, my Lord,
Are you going to be paying?
I'm a party to this case, and as counsel, I have a duty to this court to draw its attention to the correct position of the law. Yes. So it doesn't, I think that it doesn't matter too much that I am not counsel for first respondent. Yes. So, my Lord, the last case, my Lords, I wish to refer your Lordships back again to the instructive words of Wood CJ in Poku and Poku at page 998. The Learned Chief Justice then admonished with great emphasis that, quote, an application to adduce fresh evidence is clearly circumscribed and only operates within its statutory limits. This rule is therefore intended to assist an applicant who has made a genuine attempt to look for evidence and has met with failure. Courts ought therefore to be adept at unmasking attempts by dissatisfied party coming through the back door and under the cloak of having come by new or fresh evidence, seek to fill in the gaps or lapses in his or her case. For the rule is not meant to aid the slothful or the indolent, the careless, negligent, or reckless litigant, whether acting pro se or through counsel. The application is not granted on compassionate grounds. Why is it that the EC, God, and so on should not go into the box? Those are not the grounds. Neither is it meant to give slovenly, particularly a litigant acting through counsel and who fails at the trial to marshal his facts carefully and fails to conduct his case properly by presenting essential evidence at the trial or through the necessary cross-examination, or also fails to conduct the necessary investigation which would have thrown light on the strengthen his case, a second chance at rebuilding his or her case. Under such circumstances, an unsuccessful attempt to lead fresh evidence cannot be met with the criticism that the court was visiting the iniquities of counsel on the client. Either for the law has made provision for redress where the loss of a suit is the direct result of recklessness or negligence of counsel. And it closes. A party who goes to court has the sole burden, and let me emphasize, the sole burden of leading sufficient evidence to prove his case. He cannot rely on the weaknesses of his opponent or rely on his opponent in prosecuting his case. And it is for this reason that Sarkodie in Berima, Jamfi, and another versus Bedu, 1963, 2 Ghana Law Reports, 596. The Supreme Court, Koram Sarkodie Ado, Olenu, and Blade JJSE, speaking through Olenu JSC, Ozel, at page 597 as follows. The plaintiff could not have called any of the other eyewitnesses because they were the very people against whom he was litigating his title. And it would be nothing but madness for a party to assume to rely on his opponents to prove his case. My lords, we rest our case.
Mr. Akotompa, I think you have to change your way. It has lost its identity as a will.
My Lord, it gives it unique identity.
My Lord, may I, with your leave, just make one short point in response as a matter of law. And my Lord, I just wish to point out that we could not, at the time we closed our case, as a matter of law, we could not have subpoenaed Mrs. Jean Mensah because she had a witness statement that she had filed in this court on behalf of the first defendant, the first respondent. That witness statement was in this court in addition to the affidavit that I referred to. So at that point in time, we could not have subpoenaed her.
Mr. Chikata, just one. Flowing from the submission from counsel, in these proceedings, this court has upheld the right of the chairperson or the first respondent not to testify.
No, my Lord.
No, by our ruling, let me land. We have confirmed her right to decide not to testify. So don't you think that there's a judicial bar as far as this proceedings is concerned?
My Lord,
for her not to testify?
No, my Lord, no. What your Lordship ruled on was the right of the first respondent not to adduce evidence.
Yes. That he is representing the first respondent.
No, my Lord, respectfully, the returning officer of the election is an individual. The first respondent is the commission. Now, and that is why respectfully I made a point that as a matter of law, at the point in time when we closed our case, we could not have subpoenaed her because at that point in time, she had put in a witness statement on behalf of the first respondent. So the only point at which the matter changed, which necessitated, that's the necessity in paragraph 15 that we are talking about. The point in time at which that situation changed was when it was indicated that despite the earlier election to adduce evidence, there would no longer be evidence used by the first.
My lords, with all due respect, this court has ruled that the first respondent never elected. So, counsel cannot be speaking to the same court and suggesting that she elected. We have to be faithful to the record of the court. My lord, the public is also listening, and they can be misled.
You see, the point I'm making is that in our ruling, we specifically say that the chairperson of the first respondent has a right not to adduce evidence. And so
not to adduce evidence. That's what your Lordship just said.
Yes.
In other words, I mean, you were speaking about the first respondent as first respondent. That's the electoral commission.
No, the chairperson.
Also specific.
The chairperson.
The chairperson
of the first respondent. In fact, she put in the witness statement as you have been referring to.
Yes.
And those affidavits were deposed by her. And so we said that specifically the chairperson of the first respondent cannot be compelled to adduce evidence. So don't you think that there's a judicial bar? And for that matter, you cannot
There's a judicial bar.
Let's stop her. And for that matter, she cannot be compelled through any other means to testify in this proceeding, so long as these proceedings are pending.
My lord, no. My lord, of course. I mean, we have every right to seek a review of that ruling if the interpretation that you're giving, if the interpretation of that ruling that you're giving is right. But the point that I wish to emphasize is that our understanding of the ruling, especially in the context of the orders, the 38, CI 87 issues. In that context, our understanding of that ruling relates to the fact that the first respondent has it within their rights not to call a witness. I mean, just all the authorities that your lordship cited in the ruling were about the right of a party not to call a witness. That's nothing more. That's what the authorities that were cited were about. So a party...
Respectfully, the last but one page.
I'm sorry.
The last, I don't know whether you have a copy of the ruling. It is annexed to the affidavit of the second respondent. Yes. Unfortunately, they did not indicate the page, but it appears the last but one page.
The affidavit of the second respondent.
No, the ruling is annexed.
Yes.
Yeah, it's annexed to the... Yeah.
Yes.
Yeah. I think the last paragraph, beginning with, the law is therefore settled that a party will not be compelled to enter the witness box and testify in support of a case.
A party. The chairperson is not a party.
Parties who decline to give evidence take knowing perfectly well that the court will be left with no option but to proceed with available evidence before it. Counsel for the petitioner has strongly submitted to us that you should not apply the Society of Lawyers case to the peculiar facts of this petition because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Lawyers case, like this petition, also deals with witnesses who had served witness statements and have decided not to give evidence to be cross-examined. Indeed, the witness statement was served by Mrs. G. Mesa.
Yes, but my lords, a party. Your lordship just read a ruling in which your lordship referred to a party. The party in this case is the first respondent, not Mrs. G. Mesa.
That is saying, under the circumstances, you declare the issue.
My lords, that is a perfectly legitimate legal separation. The EC is a corporate body, and the returning officer who happens to be the chairperson of that corporate body, you cannot, with respect, you cannot make the two identical. My lords, otherwise, why would the Constitution make the returning officer? The Constitution is quite clear in separating the role of in her distinct capacity as chairperson, not the EC. So, my lord, I was just responding to the point about, lack of due diligence and so on and so forth, and I was just pointing out that at the point in time when we closed our case, there was a witness statement signed by the first respondent. That is our submission. That witness statement, yes, that's all.
by court. This petition is hereby adjourned to tomorrow, that is Tuesday, the 16th of February 2021 at 10 o'clock. Please, it's 10 o'clock a.m.
My lords, with all due respect, I have a little prayer to make. My lords, this court directed us last week that we should all file our written closing arguments.
The other stance.
If your lordship will hear me out, if you, on by Wednesday, simultaneously, my lords, we have seen a situation where the court has ordered parties to file their witness statements by a certain date, and others applied for review and used it not to file, with the effect that we filed our witness statements before they filed. My lords, I just want to pray an order to the registrar that if we file our witness statement on Wednesday and the other party has not filed closing addresses, and the other party has not filed because of maybe a review, they should not have any sight of our closing address. Yes.
5 minutes after you file.
My Lord, that's our plan. I think it's important to give integrity to the order of the court that all parties must file on Wednesday simultaneously.
As your lordships have indicated, this is a court of record. If he wishes to make an application in respect of the order.
Is it by implication that you are not going to file your closing address?
My lord, this is a court of record, so we'll stick to our record.
All right.
And they call me Eugene. Oh yeah, yeah. When you need a shoulder to cry, run on my pumping, so we try our suicide. Let bygone be bygone. I didn't see what the body. I'm gonna take you to next level. My baby, oh yeah, yeah, yeah. The energy next level. Back baby, oh yeah, yeah, yeah. I'm gonna take you to next level. My baby, oh yeah, yeah, yeah.
I don't go next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
When driving, you must concentrate totally on what is happening in your vehicle and your surroundings. Don't get distracted because distractions cause crashes. Some of these distractions include arguing with a passenger.
She bring me, but I don't want to.
Also, a long look at a pedestrian will distract you. Other actions that can distract you as you drive include fidgeting with the radio, reaching across to look for something in the car, using a mobile phone or earpiece, trying to fasten a seatbelt, trying to adjust the seating position, and fishing for coins. Please focus on the road as you drive. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
This advertisement has been vetted and approved by the FDA.
A good papa. Ganabam, if your wapo, your waist, all your body, you make a bazaar.
Thank you so much.
Thank you. Waiting here from doctor no. Where then? Oh my side. 20 cedi. Mr. Tiabako. Ghana Bam. Young talk about to her. I first Tiabako. I first you be 20 cedis. Hey. We need doctor. Nemo say we Ghana Bam come. Say I'm two. So if we can Ghana Bam. You can.
And they call me Eugene. Oh yeah. When you need a shoulder to cry, run on my pampers, so we try to suicide. Let bygone be bygone. I didn't see what the bottom go do. They go straight to stardom. And I go take you to next level. My baby, oh yeah. The energy next level. Back baby, oh yeah. Take you to next level. My baby, oh yeah.
I don't quote next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Don't forget the balloons,
Check.
the DJ.
And they call me Eugene. Oh yeah. When you need a shoulder to cry, run on my pampers, so we try to suicide. Let bygone be bygone. I didn't see what the bottom go do. We go straight to stardom. And I go take you to next level. My baby, oh yeah. The energy next level. Back baby, oh yeah. Take you to next level. My baby, oh yeah.
I don't quote next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Don't forget the balloons,
Check.
the DJ,
Check.
and the drinks.
Listen, honey, I've got this party under control, okay?
Daddy, don't forget our birthday cake with the sparkly candles. Daddy, are you there?
The parties are 4 p.m., honey. Don't be late.
With the all-new CowPay on the Cowbank app and website, you don't have to worry about carrying cash. Just place your order with your favorite merchant and pay with a Visa or MasterCard, mobile money or Cowbank account, or scan and pay. Visit the Play Store or App Store and download the Cowbank app today. Cowbank app. Forget the cash.
Cowbank. Forward together.
The Ghana Trade Fair Company, under the Ministry of Trade and Industry and the One District, One Factory Secretariat, welcomes you to the 25th Ghana International Trade Fair, the premier virtual edition under the theme Developing New Trade Opportunities through Digital Channels. It will be 1 month of exhibition and enterprise, offering manufacturers, suppliers, consumers and various service providers the opportunity to network and make sales. This will be over 500 local and international exhibitors, factories featuring companies under 1D1F, Rural Enterprises Program, Ghana Export Promotion Authority, and more, all on one virtual platform from the 27th of February to the 28th of March. Get access to a virtual networking lounge, allocation of a virtual booth, and enjoy a unique virtual experience. Visit our website on www.straightfairgh.com to register or call 024-446-9451 or 050-001-5587. Don't miss out.
Hello, Mr. Lagaligi.
Hello.
Hey, your football team is almost complete. Yes, so you and your partner should get hooked to the female one. It gives more stimulation and has no allergy. Yeah.
The female condom, available at all major pharmaceutical and chemical shops nationwide.
Michael, we're supporting a new system.
Pacho, I don't need
Let's not go be a 2 go many better.
Because supporting my business for your immune system. Hey, that's a Chevical t-shirt. Bato t-shirt. The cover of the funk, I know. T-shirt to go, mommy.
Boss, thank you, Mr. Willie one.
Okay.
Michael, I'm supporting a new system.
Any well-being.
Vital 20 is not suitable for children and 12 years of age, pregnant women, and lactating mothers. A quality product from Joy Herbal Center. This advertisement has been vetted and approved by the FDA.
This advertisement has been vetted and approved by the FDA.
Ganabam, if your what was apostle, your waist, all your body, you make bazaar.
Thank you so much.
From doctor no. Where you there?
Oh my side there, 20
Ghana Bab, young to Emma, Emphasize about 20. I think you will be 20 cities.
Nemo, say we Ghana come. Sound two, so if we have Ghana, you can.
That was the motion or notice for leave to reopen case of the petitioners to enable the chairperson of the Electoral Commission to testify.
and you had arguments coming from the petitioner's lawyer, and also subsequent arguments which is against that particular motion coming from the lawyers of the first respondent and the second respondent. You're back here in our studios. We're waiting for the press conference, and also pick that one. And after we engage our resource person, Dr. Kweku Ajiman-Budu, who is a lawyer, who's a law lecturer, and also the head of Law Center's Gimba Faculty of Law. Morris, it's pretty much of a long argument. Though.
Sure. So it's been close to 4 hours of argument. The petitioners arguing for reasons why they should be given or granted leave to reopen their case, and also subpoena the Electoral Commissioner. Now we're getting confused whether they're going to subpoena the person, Jane Mensah, or the Electoral Commissioner, who holds that constitutional office. Who is also Jane Mensah. So that is going to be determined. They are saying that they were giving some indications that the chairperson was going to mount the witness box and adduce evidence. And so they relied on those indications. And so because that didn't happen, they feel that they have a strong case to, at this point, open their case and subsequently subpoena the Electoral Commissioner to come and testify. The first and second respondents have said that this particular argument that they are putting forward is not sound, is weak, because the fact that they gave you indication does not mean necessarily that they were going to mount the witness box. And also, the Supreme Court has ruled that the Electoral Commissioner, and for that matter the first and second respondent, have the right not to mount the witness box and adduce evidence. And so they believe that particular ruling is conclusive.
Okay, let's hold on for now, Morris. Let's move back to the Supreme Court for the press conference from the two parties, the NDC and the NPP. We'll return and continue with our conversation. Stay with us. We'll be right back.
Morning at 10 o'clock, they will give a ruling on it. Just a quick recap. Today what has happened is that the petitioner brought an application before the court asking for permission or asking for leave to reopen their case, as it were, to go back and reopen their case and seek to adduce some new evidence before the courts. And counsel for the first respondent and the second respondent have been opposing that application. I will come to the specifics of their argument and what we've been arguing and what we look forward to tomorrow. But let's go back. Why are we here? The petitioner has told the Supreme Court of the Republic of Ghana that, among other things, nobody won this election and therefore there should be a rerun. And has notified the court that he has 5 witnesses who will prove this. The court gave orders that all parties should file witness statements and indicate to the court. A witness statement is an indication to the court the summary of the evidence in chief. Indicate to the court how many of these you want to put in or you intend to rely on. If you read CI 47 and CI 87, you intend to rely on. That's the expression. Now you will recall that the first and second respondents complied and the petitioner did not comply initially. And the petitioner then came for leave after we had filed our witness statements to file his witness statement. Be that as it may, the many attempts to put impediments in the way of the full trial gradually were removed by the court, and we got to the full trial. The petitioner initially called 2 witnesses who were expecting to come and make their case. And for all of those who have followed the trial so far, it begs the question, or it remains at large, whether or not the initial 2 witnesses were able to make the case for the petitioner. The petitioner then sought leave to bring in a 3rd witness, Ms. Rojo Metil-Nunu, who then brought in a witness statement and then came to testify. And then at the end of Mr. Rojo Metil-Nunu's testimony, without any compulsion from any quarters, the petitioner announced to the court that he had closed his
case, he was done. He had finished making available to the court all the evidence necessary for the court to find in his favor. The first and second respondents, when given the opportunity, then announced that they were also closing their case. They did not think that the petitioner had raised any reasonable cause that required them to bring in witnesses to come and testify, despite the fact that they had initially suggested to the court that if it became necessary, these were the witnesses they intended to rely on. It is at this point that the petitioner has brought a new application to the court, after the court has made orders that we should file our written addresses, I think by Thursday, by Wednesday towards final judgment. Now, the petitioner is asking the court to give it permission, because it's not a right, to give it permission to go back and reopen the case and adduce some new or some fresh evidence. It begins to beg the question, why would somebody who has told the court that I've closed my case, I've made my case, I've brought all the evidence and the witnesses that I believe can make my case, who earlier argued that this was an ironclad case, this was solid on all fronts, why is the petitioner now asking for permission to go and open the case to adduce new evidence? When you ask, the argument they make is that because the Electoral Commission through its chair advertised to them, indeed the word they used earlier today was promised, that they will also get in the box. Well, as has been explained by our counsel and indeed the bench through its previous rulings, the response to the court order to file a witness statement and even the affidavit on interrogatories do not constitute a promise to get in the witness box. And in any case, if you have an opportunity to cross-examine, you cross-examine in chief. So if the respondents have not gotten into the box to provide evidence in chief, what is this cross-examination going to be on? The court has already ruled that a party cannot be compelled to adduce evidence. Today, you have seen our colleagues come with an application asking for a subpoena. What's a subpoena? To compel the EC chair to get into the box. So the very thing the court said the last time we were here, they've come with an application with a different name or different instrument asking the court so to do. You also heard learned counsel on the side of the first respondent and second respondent raise a number of reasons for which the position of the law does not support the argument that they are making. And I hope you took notice of the fact that for several minutes, the Venerable Akoto Ampah on his feet was citing various authorities in times past that do not allow the party, that is a petitioner, to do what he's seeking to do. I want to end by reiterating two of those authorities. One, Poku versus Poku, the former Chief Justice Georgina Wood. And I just read to you. An application to adduce fresh evidence. And why we are saying this is fresh evidence is because when you come and ask to reopen your case, why are you reopening your case? You want to reopen your case because there may have been something that was unavailable to you, which you are making now available to the court. And that is why we're asking the court to apply the rules of adducing fresh evidence in this instance. If not, then you are saying that you want to lead further evidence on something that you've had an opportunity and you've led evidence on already. And you are now probably thinking you didn't do good enough of a job, and that's why you want it reopened. But the letter Chief Justice, as she then was, said an application to adduce fresh evidence is clearly circumscribed and only operates within its statutory limits. The rule is therefore intended to assist an applicant who has made a genuine attempt to look for the evidence and has met with failure. Courts ought therefore to be adept at unmasking attempts by a dissatisfied party coming through the back door and under the cloak of having come by some new or fresh evidence, seeking to fill in the gaps or lapses in their case. For the rule is meant to aid the slothful. The rule is not meant, I beg your pardon, for the rule is not meant to aid the slothful or the indolent, the careless, the negligent, or the reckless litigant, whether acting pro se or through counsel. So whether it's Mr. Mahama or his lawyers who have been indolent or careless, negligent, reckless, the rule does not support them. The very final quotation that I want to reiterate, as articulated before the court by the Venerable Akoto Ampah, was in the case of Berma Jemfi and another versus Bedu. The Supreme Court, Koramsa Kodiado Olenu and Blay, justices of the Supreme Court, speaking through Olenu, observed at page 597 that, and here's a quote, the plaintiff could not have called any of the other eyewitnesses because they were the very people against whom she was litigating her title. And please listen to this part. The Supreme Court says it will be nothing but madness for a party to a suit to rely on his opponent to prove his case. The Supreme Court of the Republic of Ghana says it will be nothing but madness for a party to a suit to rely on his opponent to prove his case. You heard counsel on our side lay all of these authorities before the Supreme Court, and we look forward to their ruling tomorrow. As to whether or not you heard the compelling legal argument with authorities backing it from the other side, I'm sure tomorrow when the justices came, they will tell us, or when the justices come tomorrow, they will tell us which of these arguments and which of these authorities have met their pleasure. Those will be our comments. If there are questions, we're happy to take them now. Yes, sir.
And the lead counsel for the petitioner asked for interrogatives. He argued in court today that your lead counsel argued then that you said that the petitioner will suffer no injury to his application if the interrogatives are not granted. Then comes the time when he's supposed to cross-examine the second respondent or the first respondent petitioner or the witness. You turn around and say that he cannot do that. And he says that they came to court with a belief that they were going to cross-examine the first respondent.
So let me quickly respond to that. There were 2 points that were made. One was that the petitioner will suffer no injuries if those interrogatories are not granted. Why? Because all the material issues, including documentation that they need for this trial, is already available to them. 2, the questions that they are seeking to ask must be of relevance to the issues at stake. And even if they do not get an opportunity to ask relevant questions, i.e., questions that between the pleadings and the answer are left hanging, that the court will require some testimony before it comes to a determination on, if there's an opportunity for cross-examination, you can put those questions forward. Cross-examination comes after you have supplied what we call evidence in chief. Now, it is expected that you would discharge the burden of proof on you, so that I feel that if I don't get in the box to lead evidence in chief, I am at peril. And then you have room to cross-examine me. So it cannot be that you then fail to meet those standards and seek to come through the back door, that you should be given an opportunity to compel the witness into the box, who has not led evidence in chief, by the way, to be cross-examined because you have not been able to establish your case in the first place. Now, the second argument of they relying even on this argument in the affidavit, it cannot be true, because you notice that they applied for a review. If they had taken it on face value, that okay, therefore, we are resting and we'll go on a cross-examination when the opportunity comes up, they will probably not have gone for a review. But you notice that they sought to go back. In fact, they did. They went back to the court to say they disagree with it, and the court ruled them out. How can you turn around today and seek to reprobate that which you sought to approbate, or approbate that which you sought to reprobate? You cannot do that. If you have taken a position that you are coming to court to make an argument before the court, gather your evidence and come and do say. If you have completed that and you have announced voluntarily to the court that you have closed your case, why are you today now showing everybody that indeed you yourself are recognizing that you did not make a case compelling enough? And that is why you are saying that until and unless the EC chair is compelled to get into the box, you are not able to complete your case. And this is the hurdle that they have to cross. We look forward to what the court will say tomorrow.
Yes, counsel for the petitioner, in trying to counter the argument put forward by the other side, first respondent, indicated that he's saying that she's not capable, will not be capable to mount the box. And so he quoted, Mr. Chikata, quoted Evidence Act Section 53 and 54, incited some cases, rules, that it might be someone, even a letter child can be allowed to go into the box, and so forth. What is your response?
So let me just put that in perspective. He didn't quote cases. We made an argument in our affidavit that, in fact, it was the first respondent who made an argument in her affidavit that she is disqualified from being a witness. Why is she disqualified? She is a party to the case. If you want to subpoena a witness, the practice has been that this is usually a third party who has information that can help your case. Here is a case in which you have brought a party to court, and you were hoping that that party will get into the box and give evidence to help your case. And the party has outsmarted you, has taken a superior legal tactic, and has said that I will not get into the box. If this is all that you have to tell the court, let the court judge based on this. Now, the party says, I am disqualified from also being a witness because I am a party to this transaction and I've elected not to get into the box. And so the court cannot compel me. What Mr. Chikata did was then to go under the Evidence Act of who is disqualified from being a witness. Yes, there's the general rule that anybody who has information that is relevant can be a witness, and the persons who are disqualified are A, B, and C. But why that does not apply in this case, respectfully in our view, is because the EC chair is a representative of the EC. The EC chair and the EC, and you heard the bench say that for the purposes of this case, you can't even separate the two. So a party, and that's why she makes the point that as a party, she's disqualified from being compelled by somebody as a witness on the behalf. But it is interesting that now the supposition from Mr. Mohammed's legal team is that when they mention 5 witnesses, because now that's what they are saying, that when they mention 5 witnesses, they intended to call the EC chair as one of their witnesses. Where are their 5? The other 2 who are going to make their case for them, where are they? Because now what they are suggesting is that until the EC chair gets into the box, they are not able to make their case. We'll hear what the court said tomorrow. Yes, sir.
So I noticed 2 main things in court today. One had to do with the application for reopening of their case, but the second also had to do with a mention of the fact that Mr. McMenu had said something which was recorded on tape, which is something that the lead counsel for the petitioner would like to play in court. Throughout the arguments of the second respondent's counsel, no reference, at least to the best of my knowledge, was made to whether or not the tape should be played. However, the second respondent's counsel appeared to be defending the first respondent and not the matters that directly had to do with the second respondent. That left me a bit amazed.
Let me quickly respond to that. In the 2013 Supreme Court election petition, the court even allowed friends of the court, amicus curiae, to come into the court and to supply a brief on legal matters to aid the court in arriving at a position. Lawyers, sometimes when you are in court and a matter is being disposed of in court and there's a point of law or a matter that you think you should bring to the attention of the court, even if you are not a party or counsel for any of the parties, you can pray the leave of the court to provide some legal support to the court as a friend of the court, amicus curiae. That was in 2013. Subsequent to 2013, the government of the day took a CI 99 to Parliament under the leadership of Marietta Briopon, Attorney General at the time, had it passed to limit or to constrain the framework of presidential election petitions. So now, you notice that even the petitioners, only one person can petition. And arguments from friends of the court are not necessarily being entertained. But the second respondent is a party to this case that is before the court, and therefore has the right and opportunity to address the court on matters of law. Even if he is of the view that some matters of law have been missed by the petitioner or the first respondent, he is well within his rights to assist the court with legal arguments on that. And so if he writes, and that's why he said with respect to the court, it's of no consequence if his argument appears to favor the first respondent. It's of no consequence, because once he's a party, and once the matters that are being discussed will affect the client, he is well grounded to advance arguments before the court. In 2013, even persons who were not parties or counsel for parties could do same. So I think that explains it. Now, the first argument of the tape, I'm sure you were all in court when Mr. Rojo Metununu mounted the box. I suspect you observed that the tape was played, was it not? The tape of Peter McNeil, Paul Adumoche, was it not played? How does playing that tape 2 times change the results of who got 47 and 51? It's been played already, not so? So what is the basis on which they are requesting for the same tape to be played again? There was no reason for us to spend time speaking English around that particular issue. It is matters of law that our counsel sought to address before the courts, and that's why they dealt with it. But that tape, if you recall, has been played already. Playing it 2 times will not change the probative value. Yes, sir.
Yeah, so just before the court rose today, counsel for the second respondent sought to draw the court's attention to make an order sort of compelling all parties to file by Wednesday. What were the concerns he was seeking to raise?
Let me quickly clarify. He was praying the court to make an order that when we file our written addresses, they ought not to be cited by the petitioner. And that is assuming we don't all file simultaneously. They ought not to be cited, because we are beginning to believe that the petitioner is adopting a strategy of waiting to see what we file and then coming back to file theirs, which will be the other way around. The petitioner is the one who was supposed to have filed his witness statements first. Despite the clear court order, the petitioner's legal team did not do it. First respondent, second respondent filed ours, and then they had to ask for leave to do that. I think the written submissions on the submission of the preliminary legal objection, for example, you find out whether or not they filed and when they filed. And that is why we are making, or that is why our lawyers are making that prayer to the court, that we don't want a situation where we come and file our written addresses, and then they, because the registry operates as a court, to create the public record, they will get an opportunity to read it, and they come and now find a way to come and respond to it. And that's why I'm making that prayer, that for the integrity of the orders that the court is making, we all either file simultaneously, or if we don't, and they for some reason, because they have hinted that they may go for a review, that's the same instrument they used the last time, review, so won't file. Then they read ours, then they come back. Because they've done it before, our lawyers are praying the court that if they adopt the same strategy this time round, the registrar should be instructed to ensure that they don't cite ours and use it as an opportunity to go and find some arguments to respond to what we have put in. We should all file ours simultaneously. Thank you very much.
Abusanfo yedamwase ene eka ho a na no nanke nim se nka ye dwumadie ene eyeda toso edunum a ye hia ewo Supreme Court court batan ha na ansa na metoa so no menu akodwo eka asem a court ankasa die odi kan ka aye openi aye berma aye jamfi ene openi bedu asem a court edie dada ho court say abusuanfo mu ntini ye agisa wa utrimu kawo besre court asem ena waka agisa wa utrimu kawo na wonu obi etwe dawere anase wonu obi enya asem na court etna so na wo so de agisa enipa na danse ena sa nipa obe sa na eba wadwimu kawo ana wadwin ena ho ne toso mienu aye asem foforo court angasa die enu nso poku versus poku tasem o kan ne se wabo nkuro awie wakan wa asem nyina awie wo court na aye empanifo ade omano asem atoso te empo o pese obana wo se bie wa asem nani biem na obeka asem ɛno no agye sɛ yehu sɛ adansedi a wode ba no ɛyɛ adansedi emu odu na sɛ emu nye du kɛkɛ o na ebetimi asesa asɛm nani na nya de a court wa wo yɛ akwadro sɛ wo de ugina oyonko asɛm so na ebedi wasɛm wa wo penna na wo nya adwuma no na court bɛboa wo dabida we yɛ nsɛm yenu a ehu hia yie paa na nanka yenim sɛ court anu asɛm obi amfa ne nsɛm mu krataa so sanse nsɛm na ɛba awie no nyame yɛ adoma anka bosom ɛwɔ mu ya ɛda ɛtosunson nanka ya sɛ hia ɛwɔ court dem hɔ yi ɛyɛ ɛda ɛtosu du wɔtwe nanso naano asɛm a yɛdiɛ ɛyɛ kwadubɔfoɔ no wabie wɔ asɛm ani wabɔ wo nkuro awie wakyerɛ sɛ okrata mu kura no na ɔsɛ nka bɛfrɛ adansefoɔ enum ɛkɔ wie akyi no ɛyɛ adansedie krata a wode bɛto court na yɛmienu ɔpani asiedu katia ɛne ɔpani pɛsa white ubɔ ni nyina wie kura court ahumɔboro ahyɛ court 20 asa busa sɛ wo adanseni biem ana ase ane na akɔyɛ mpomuden ho sɛm enti ɛba saa no a lawyer fo nyina ne a judges fo ɛkɔ kokoam ne kopie ne sɛ ɛyɛ ɔpani rodo metonu no so ɛma ne de nano asɛm ɛbɛto court yɛtoto nano nyina wie yɛ no court sɛ busa biem sɛ kwadubɔfo yi anyabia no wasɛm a wode ba court no wawie ama ɔmo agye tumu sɛ ampa yɛwie yɛbɔ yɛn kura wie adansefoɔ yɛafrɛ mu nyinaa yɛnyina so nyinaa yɛde abɛto manim enti yɛasɛm no deɛ yɛaka wie ɛhɔ ɛna court so kɔ anoyifoɔ a odi kan first respondent sɛ ɛneɛ nso hyɛ ase ne bɔ wo nkuro ɛyɛ lawyer ni a ogyina mu ma no epagya ne ti ɛsɔre gyina hɔ no ka sɛ wɔwie na asɛm ka wɔwie na asɛm ka sina no modi kan ɛde ato dwa dada sɛ nsɛm a yɛ kwadubɔfo no de aba bɛto dwa de aba court dem no enyina so bi anim ɔmo dansidie no ensisi so ɛno nti no ɛnya de a ɔmo wa no yie bia ne mpokra no ɛyɛ nka ɔmo dansini ɛyɛ maame den mensa nanka ɔmo agina no asɛm a yɛfrɛ no witness statement yi ɛde aba no ɔmo na akora mfrɛ ne biem sanse ɛyɛ ensɛm a ɛyɛ kwesa hot bɛka yɛ ɛne rojo metunu no bɛka yɛ no ama ɔmo asɛm no kora no ahyɛ mu kena ama ɔmo asɛm no mu ayɛ du sɛ yampa no kwasɛm nie ɛyɛ saa anoyifo ɔtɔso mienu second respondent ɔmo so gyina hɔ sɛ yɛn so yɛ na kora mfrɛ yɛ kyɛma makmanu ɛna ɔbɛka na asɛm biara ɛyɛ kwadubɔfo yi a ɔmo so motiko apae adɛyɛ a yɛmfa asoma ahoma ɛnsɔ ɛyɛ maame den mensa na ɔmmra bɛgyina daka mu adɛyɛ sanse ne nsɛm bi a ɔka ɔkɔ tanim no ɔkyerɛ sɛ empokra no sɛ akwanya bana sɛ ogyina daka mu a nsɛm ne bi wɔ hɔ a obenya no ayi ɛno nti no ɔmo no deɛ ɔmo gyina hɔ no ma sɛ kyinkyini a ɔmo pɛ sɛ yɛbie ɔmo asɛm n'ani yɛbie ɔmo asɛm n'ani awie no na court nso sanhyɛ n'ano mokayɛ aborɔfo kɛseɛ baako a ɛbɛtɔ dwa na yɛ interrogatories ɛnɛ ni asa babiem ɛyɛ subpoena ɛno ne nkyerɛaseɛ no ɛkakra bi sɛ court ɛnhyɛ ɛyɛ madam Jemensa no mmra no mbɛgyina adaka mu na ɔmo ntoto nano ɛnɛ ɛhɔ ne baabi a yɛduruyɛ na abusuafoɔ asɛm kaeɛ a judge pani baako busa sɛ nano yɛ ɛna yɛayɛde yɛ no asɛm bɛto dwa yɛka sɛ ɛyɛ ɔbaa Jemensa emra bia ni hɔ no ma ɛhyɛ keten sɛ agye so obegyina adaka mu akasa ɛno nti court deɛ ɛnya deɛ a saa asɛm a ɛyɛ kodubɔfoɔ no ɛpɛ no ɔmɛfofa so ɛno nti sɛ nei ɔmo saa ɛma kwan biem sɛ yɛnkɔ wɔ asɛm nani ne yɛnsamfa tumi ma wo sɛ yɛmfa ahoma nsɔ ma megye mensa kon na ɔmegyina adaka yi mu na ɔnka na no asɛm a ɔnyi ni asɛm a yɛaya no kaeɛ no ana yɛsae de yɛ no ɛsa akɔ akɔfa ne asɛ tietia so sɛ yɛka yɛ boa sesia de ɔbapa Jemensa obetumi obegyina court nim abusuafo asɛmsɛbɛ ɛhɔ ani baabi a yɛba beduru nyame yɛ adom a ɔkyena ɛna court ɛde n'ano asɛm ɛba bɛto dwa ɛno nti mesre asɛm baako nɛ ɛsan bɛto dwa na ɛho hia yie paa na court sɛ ti mu biem sɛ maame gye mensa sɛ ɔde n'ano asɛm agu krataa so ayɛ fɛ no witness statement na ɛnya adanseɛ ɛno nkyerɛ sɛ ɛwɔ sɛ ɛhyɛ no sɛ kyinkyina ɔma bɛgyina adaka mu enti ɛno deɛ kwadubɔfoɔ no ɛnyɛ ka ɛnɛ ɛno nso ɛbɛto dwa abusuafo yɛbɛwie no yɛ lawyer pani ɛsɔre gyina hɔ ka sɛ ɛyɛ court nhyehyɛeɛ a ɔde aba court akwankyerɛ a ɔde aba sɛ obi biara mfa n'ano asɛm nkukyiri ngu krataa so na nyame yɛ adom a ɛda a ɛtɔ so du nson yɛmfa no nyame bɛto court anim na ɛda a ɛtɔ so du wɔtwe ahyia no ɔbɛsrɛ sɛ court ɛma no nyɛ wo hyɛ san sɛ yɛhu sɛ kwadubɔfoɔ no ɛyɛ a na ɔmo nsɛm no ɛtae sɛnti no abere biara no ɔmo bɛ sɛ ɔmo de ɔmo no titɔ hɔ na ɔmo hwɛ yɛn nea yɛyɛ eti court nhyɛ sɛ obi biara mfa ne krataa ɛmmra ɛbrɛ a obiara de ba eti nya sɛ wei edi kan ba na wei akɔ teta baabi na ɔno di kan de ne de aba eti court nhwɛ sɛ saa de no ɛbɛkɔ so ɛna ebiem ɛnyɛ sɛ court saa de na no asɛm aba sɛ na no mo bɛka ya court sɛ yɛmfa ya dansidie krataa mmra no na afei na obi sɛ ɔno deɛ ɔde application for stay of proceedings ɔde nhyehyɛeɛ bi anaasɛ ɔde adesrɛdeɛ akɔto court anim sɛ court ɛntwentwɛn ne dwumadi a ɛwɔ di so nti no wɔandi saa nhyehyɛeɛ no so daabi wei ɛyɛ nhyehyɛeɛ a court ɛdi aba enti ɛwɔ sɛ obi biara ɛdi so abusuafoɔ wei ne baabi a yɛbɛduruiɛ nyame yɛ adom a dasɛnɛ yɛbɛsan ahyia ɛwɔ firiam ha sɛ biom ɛyɛ yɛlɔyafoɔ a ɛnɛ ɔmo ka yɛn ho ha sɛ Hajia Fatima Abubakar Mamunim Minister Designate for Information still maintain Kojo Opon Kroma ɛwɔ ha sɛ Patriot Faisal lawyer nso ɛwɔ ha sɛ ɛna yɛlɔyafoɔ ɛma nyame no nupɛ ne yɛka nhwehwɛmu ne mpɛnsɛmpɛsɛmu a yɛyɛ ɔmo ɛna tɛkyiri ɔmo bɔ ɔmo ho dwuma yie paa ɛnɛ nso lawyer Kutampao lawyer Frank Davis lawyer Kwaku Asrifi lawyer Adodapa lawyer Joyce Opoku Boateng lawyer Shelamin Kampremo lawyer Victoria Buff lawyer Ochere Ajekum lawyer Dr. Ernesto Sudapa na professor Yaw Opon lawyer nso bɛka ho Keyamo a nso kan ho ne ɛnɛ kyɛma menu nso bɛtae yɛkyi ɛnɛ ɛna ebiem lawyer Gabi Ochere Dako nso ɛbɛka yɛ ho ɛna lawyer Kowo Suman medam ase nyamhyira mo
Yes. Nana.
Yeah. Yeah. Okay. Okay. Good afternoon, ladies and gentlemen of the press. Today, before the Supreme Court, the lawyers for the petitioner brought a motion or an application to reopen his case on the grounds that were stated in the affidavit of the petitioner. And the basic ground was that at the time that the petitioner closed his case, the petitioner did so with a legitimate expectation that the petitioner would have the opportunity at the appropriate time to cross-examine the witnesses of the respondents. Now, ladies and gentlemen, you realize that the respondents filed witness statements. They also represented to the court that they were going to make themselves available for cross-examination. So at the point in time that the petitioner closed his case, he had that legitimate expectation that he would have the opportunity to cross-examine the chairperson of the Electoral Commission in particular. Now, let me put it right that certain misrepresentations have been made to you this afternoon. It is not true in law that a party cannot be asked to testify or a party cannot testify at the trial.
That is not true. That's not a true legal position. In fact, you were all here in 2018. His Excellency the Vice President, Dr. Mahmoud Bawumia, testified during the election petition that was filed by himself, His Excellency Nana Addo Akufo-Addo, and Jake Obichebi Lamte. They were all parties, but there was a party and he testified. So it is entirely wrong to say that a party cannot testify at a trial. In any case, the subpoena that we are seeking to bring or to file in court is not designed to make the Electoral Commission as a corporate entity to testify or file a witness statement and be cross-examined. It is directed at Madam, the chairperson of the commission, and the returning officer under the Constitution for the 2020 general elections. Now, I must put it on record that I'm different body. There's a long line of decided cases